Lords and Lady, I believe you have now had handed to you, or about to be handed, the pre-action protocol, the portal. I'm grateful to whoever it was that arranged for that to be done. In response to the questions about statutory framework for the short adjournment, it perhaps might have been better if Mr. Ryman Tubb had said that the MIB lies at the heart of the system for compensation of victims of motorists, which system is itself statutorily based. The history is that in 1946 the Castle Committee reported and pointed out the gap in the ability of victims of motorists to recover compensation if an insurer couldn't.
No, I mean, I understand the background. I just
so that's it. Well, the current position is that the Bureau has agreements with the Secretary of State, and it is the Bureau that fulfils the
they're
government's
not made
obligations.
under any statutory power of the Secretary of State.
No.
Under some sort of prerogative.
The agreements are the untraced and the uninsured to effectively to carry out the UK's obligations pursuant to Articles 3 and 10. Those are in the authorities bundle too.
No, I mean, I've seen those. Again, there's no domestic regulation.
No, there's no mystery to it. And the other part of the statutory framework is the Road Traffic Act itself, which you also find in that authorities bundle. It begins with section 143, which is behind tab 2 in the authorities bundle 1.
Well, there's a reference to the definition of
Authorised motor insurer.
But that's the only actual specific statutory reference.
It is. Thank you.
Mr. Williams.
My Lords and my Lady, before I begin my submissions, may I just fill one gap in the representation. I don't think my learned friend, Ms. Anneli Howard, was introduced to the court, but she is also appearing with me along with Mr. Smiley. My Lords, in our submission, the first question to arise in this case is whether there is a legislative intention that where insurance has been issued in respect of a vehicle which has been identified, the insurer must be the primary source of compensation. And we say the answer to that is yes, both because of the Road Traffic Act, and that's the point which the Court of Appeal decided, and I'm not going to say a great deal more about that than to say the majority were right for the reasons they gave. But secondly, because of the general provisions of the 6th Directive, and thirdly also because of the specific right of direct action in the 6th Directive. And it's that leads us to submit there is a legislative intention of the sort that we posit. Now, if we're wrong about that, then our case goes no further. If I can use a time-hallowed phrase of European law, we are kaput. Because there clearly is not room for procedural innovation to give rise to that, to give effect to that legislative intent if that legislative intent isn't demonstrated. So I'm going to first try to make good the existence of that legislative intent. Now, if I make it good, one then has to ask, is there a gap in the remedies in our procedural law, and if so, can it be bridged? And it's in that context that I will need to address the questions that were identified by my Lord Sumption. And then ultimately, I suppose there is the question, well, if it can be bridged, should it be? And that's a matter of discretion. Though we say if we're right about the first 2 points, that there is a gap, but it can be bridged, then it's a pretty obvious exercise of discretion that it should be. So let me deal with the question of the legislative intention first. And because the Court of Appeal deal comprehensively with the arguments on the Road Traffic Act, I am going to concentrate my oral submission, and we cover those in our case. I am going to concentrate my oral submissions, if I may, on the European dimension. Now, so far as that is concerned, we do submit that an inability to obtain compensation from an insurer on risk for a culpable vehicle, if I can use that shorthand, because of a domestic procedural requirement to name a driver would be inconsistent with European law. And we say the aims of the European legislation now consolidated in the 6th Directive are twofold. Firstly, to ensure that vehicles are covered by compulsory insurance, as this vehicle was. And secondly, that victims of accidents are able to obtain compensation in full for harm caused by accidents involving vehicles covered by that insurance. And it's that which leads us to say that EU law indeed requires the principal source for such compensation to be compulsory motor insurance where it exists, and it's only where a vehicle is utterly uninsured or utterly unidentified, so, and where ex hypothesi an insurer is not going to be identified either, that there should be a recourse to a national guarantee fund such as MIB. And we go further and say that on established principles of EU law and in line with the duty of sincere cooperation, national courts should strive to give effect to that objective if they can. And obviously I'll return to that when I come on to whether there is legitimate domestic scope for procedural innovation, if I can call it that. Now here it's common ground. The culpable vehicle was insured, and the only barrier to obtaining full compensation from the motor insurer, which is identified as the point of procedure, we can't name a wrongdoer, ergo we can't get a judgment, ergo we can't trigger the mechanism under the Road Traffic Act, and for the reasons my learned friend Mr. Worthington gave this morning, the direct right of action under the 2002 regulations doesn't avail me either, because they require the insurer to be contractually at risk, and here of course it's common ground that the insurer wouldn't be contractually at risk because it appears that the policy was obtained in circumstances which would have allowed the insurer to refuse cover on multitudinous grounds. The initial misrepresentations and non-disclosure, the fact that the vehicle was being driven by someone who probably wasn't allowed to drive it, and lastly, of course, the total failure to cooperate with the insurer after the claim was intimated. And for all of those things, it's all...
The reason he's contractually not liable is not simply that there's a special defence such as avoidance and so on. It is simply that the cover did not extend contractually to the person who was driving it, whoever.
Well, I would certainly proceed on that assumption. It's a particular feature of the case that we haven't, I think, got, the Court of Appeal commented on it. We haven't got the policy in evidence, but I think that may safely be assumed.
Well, I understood that to be common ground.
Yeah, absolutely.
Everyone agrees that it wasn't the named policyholder.
Precisely. If we're right, we say that there isn't, in fact, difficulty with the court disapplying procedural requirements to ensure that rights under union law are effective, just as there hasn't been difficulty in disapplying it in other contexts, like injunctive proceedings. I do want to emphasise, however, at the outset of this submission, that, and it goes to the floodgates arguments that both my learned friends have adverted to, either orally in the MIB's case and in writing in Mr. Worthington's case, that there are floodgates to be opened here. I mean, it is very important that I emphasise that our submission is directed at vehicles which are identified and insured, but a tortfeasor cannot be identified by name. And that is the only circumstance to which our submission goes. Certainly we would say there is all the points that I will be making about the directive, making it clear that where there is an identified vehicle and an identified insurer, the insurer is the source of compensation, would not be available in cases where there is not an identified insurer.
It isn't simply that the person can't be identified by name, is it? I mean, they can't be identified in any way at all. You don't know their sex, their age, nationality. You know absolutely nothing about the person, which might be contrasted with a situation where you have, for example, a number of Greenpeace protesters who occupy an oil rig, and you don't know their names, but it's possible to ascertain their other characteristics.
Well, I mean, if they're still on the oil rig, I can quite see that you can say the people who are sort of sitting at the top of the tower, preventing the flame from being ignited. I can quite see that. Clearly, there are other circumstances in which it would be possible to identify people by a more accurate description that would still be pretty useless, like the Caucasian gentleman with a beard, who jostled me on the number 93 bus. Obviously, there's a question as to whether or not one needs that level of precision, and my submission will be that one doesn't. Certainly in the authorities we've had to date, albeit I recognised they're in the context of injunctions. One often hasn't had that level of precision. It's just persons unknown. Mr. Justice Laddie in the Bloomsbury case suggests, well, you might be able to sue somebody with reference to a photograph, for example. I suppose you might have a still from CCTV footage that caught the sort of blurry, absconding, uninsured driver from a street camera. But I mean, our proposition is essentially that in the light of the domestic jurisprudence about dispensing with the need to give a name, which isn't accompanied by any jurisprudence about the need for great precision in the description of the wrongdoer. I mean, essentially, I'll be very frank about it, we are trying to bridge what we say is a gap. It's common ground in this case that if we could have named the tortfeasor, even if the name, for example, was a known alias rather than his given name, the insurer would have no answer. It's common ground that if we named him but then he vanished, as they often do, the insurer would have no answer. It's common ground that if by the time we came to issue proceedings, or it used to be common ground, that if by the time we issued proceedings we could no longer trace him, that we could still issue proceedings and get alternative service on the insurer itself.
Why do you say that there's a gap? Because, I mean, you're assuming that the MIB's existence and role doesn't fill the gap.
Yes.
That's rather a large assumption to be making, isn't
Well,
it?
it's obviously, my lord, something that I'm going to have to try to make good. But if I can presage what it is that I'm going to say that the European legislation in particular provides for compensating liabilities for insurers and compensating, let me call them compensating obligations. Compensating obligations for insurers and compensating obligations for guarantee bodies. Now, those obligations are not the same. I mean, just to give you one immediate answer, the directive forbids insurers from levying an excess on third-party claims. The directive permits guarantee funds to levy excesses on third-party property claims. And therefore, even if you have a right against MIB, if you are meant to have a right against an insurer, you will not have the rights that the directive guarantees to you, because MIB will be perfectly entitled under the directive to levy an excess, but the insurer would not be. And that immediately, therefore, is an illustration of a gap.
But it doesn't, in fact, have an excess. It doesn't have an excess. So financially, it's equivalent.
No, the MIB does have an excess for property damage claims.
I see, but not for motor claims.
No, for if your car, for example,
I
is
see.
damaged.
I
Yes.
follow. Right. Okay.
Yes. The position roughly is it has an excess for pure property claims. There is the directive doesn't allow an excess of more than €500 in cases where there is significant personal injury. But it still allows an excess of up to €500. And I think in domestic law, I'll be corrected, the excess is £300. But well, that sounds as if it's about right. I mean, those are some preliminary observations. So before I embark on what I'm afraid will be an exegesis of the directive that's slightly fuller than the one you've had, I'm just
Can I just be clear? I mean, the
me,
road traffic scheme has existed long before you were members of the
Oh, indeed.
Europe.
Yes.
You're saying there was some sort of implied amendment of the scheme when we went into Europe to comply with or when the directive came out to comply with that, or there weren't any regulations? What's the sort of process by which the directive resulted in amendments to the scheme?
Well, I mean, for the first stage of my argument is to inquire whether or not the directive gives me rights which, on my learned friend's analysis of the law, are being withheld from me by domestic provisions. And if the directive gives me those rights, then the Marleasing and its satellites principle of consistent interpretation clearly applies, and it applies to provisions that pre-existed the directive and indeed even our membership, as well as new provisions that have been introduced since our membership. So, for example, I mean, let us assume there was no controversy about the discretion to issue process against, against unnamed people. If I was to persuade the court that the directive required domestic law to allow me an effective remedy against a motor insurer such as the Liverpool Victoria, then the Mar leasing and its satellites would enable me to say that that is something the court is duty-bound in exercising its discretion to allow process to issue against unnamed drivers to allow in this context to give effect to my right, when the only thing which is preventing the exercise of my right is the inability to name the tortfeasor individually.
Well, it's also the fact that contractually the insurer is not the insurer of this particular driver.
Well, it clearly is not an insurer as a matter of contract,
No.
but I mean that is the very point I pray in aid. The way in which the directive expressly operates, to say nothing of the way in which it has been expansively interpreted by the Court of Justice for nigh on 2 decades, is that insurers are liable to cover third-party liability in practically all circumstances, even if they would have no enforceable contractual obligation to the policyholder.
The problem is you're relying on a tool for that purpose, which is directed to a different problem. The object of the direct right against the insurer is simply to operate as a cut-through. In circumstances where the tortfeasor would be liable, his insurer can be made directly liable as opposed to operating through subrogated powers and directing the litigation and so on. I don't see how you can apply that to somebody who is not in the relevant respect the insurer. Neither the directive nor Section 151, as far as I can see, requires one to make him the insurer of that person. It just means that he is liable, although not insured, in certain circumstances.
Well, that, with respect, is where your Lordship and I would part company, because I say that the directive, both in its general scope and also specifically under the new right which it grants in Article 18 of direct action, does have that effect. And so, I mean, that's probably what I ought to address.
Yes.
Now, clearly, in addressing that, I'll just mention, though I know they will be very familiar, some principles. So clearly, the court will have in mind, if I'm right about the extent of the rights which the directive creates, firstly, the duty of sincere cooperation under Article 4.3 of the Treaty of European Union. And secondly, the obligation under Article 19 that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law. And as your Lordships, your Ladyship know, I mean, that is now echoed by the Charter of Fundamental Rights, basically to the same effect, that where rights guaranteed by union law are violated, there should be an effective remedy. And then lastly, there is the duty of consistent interpretation, which we all still tend to refer to via the label of Mar leasing. But we say, and I apologise because I suspect all this is very familiar, in the subsequent jurisprudence of the Court of Justice, what Mar leasing has been held to amount to is much more than a mere principle of strained construction. It is an even more muscular principle than that, and I will come to the relevant authorities.
And is that so even in a situation where the issue of rights and obligations arises between two private parties?
Yes, because it is the court's obligation. I mean, I'm not suggesting that the directive gives me directly effective rights horizontally, as against the insurer. But when the court, again, can I test it?
Simply talking about our interpretative obligation.
My Lord, yes. And if I again just test it with the example I gave a few minutes ago, if your Lordships are with me, firstly, that the directive does endow me with the rights I assert, and secondly, that the only barrier to those rights is an inability to name the defendant wrongdoer, and thirdly, that what was previously common ground, that it's a mere matter of discretion as to whether the courts allow process to issue and judgment to enter against an unnamed wrongdoer, then in exercising your Lordship's discretion, I mean, that is where principles, and or indeed, if I may respectfully say so, obligations of sincere cooperation and consistent interpretation would as it were, bite. So I think I'll be corrected by Ms. Howard if I'm using European terminology inaccurately, but no, in fact, she's just given me the very word I was about to use. This is what is sometimes called in the Luxembourg jurisprudence a triangular relationship or triangular direct effect, although at the base of the triangle you have claimant and defendant as private individuals who cannot invoke the directive. At the apex of the triangle you have the court as the arbiter, and in conducting its arbitration the court does have to have regard to the directive and to use all the legitimate tools within its disposal to give it effect if it can. Yes. Yes, and I'm also reminded, and your lordships, your ladyship will know that I say this with very great respect. I mean, those obligations are all the more paramount in this as an ultimate court of appeal in a national territory than they would be, and indeed as they have been in the lower courts thus far. So I have to say, I recognise I made a slightly crab-like progress to the exegesis of the directive which I threatened. So perhaps I can commence that exegesis in the sort of 90 minutes odd I have available to me. So I'm not suggesting it's going to take all 90 minutes. I hasten to reassure. My lords, my lady, it's Authorities 1, tab 11, MS 1025. I know it's a document you visited already. And just before I start the journey through the instruments, just to summarise the points, what I'm going to say this shows, and I know I've preempted some of this. First, if there is insurance attaching to the vehicle, it is the primary source of compensation. Secondly, it's an important principle, again, to a significant extent for a reason I've anticipated in a reply to my Lord Lord's assumption, because guaranteed bodies are permitted to restrict compensation in a way insurers are not. Thirdly, and this has been preempted in submissions this morning, the Court of Justice has said in the clearest terms the national body is a fund of the last resort, which is not to be called upon where any insurance attaches to a vehicle. And fourthly, and this is an important refinement, and it perhaps goes to the observation of Mr. Justice Jay, which my learned friend referred to this morning in the Delaney case, it's at least not to be called upon as a matter of obligation. I accept, of course, there's nothing to stop a nation-state allowing a victim recourse to the guarantee fund as well as an insurer and allowing an election between remedies. And it may even be, if what MIB says is right about the fine attributes of the supposedly fine attributes of its UTDA scheme, that is something that some victims would choose to do. But if I'm right in my primary submission, it is not something that can be imposed upon them as a matter of obligation. It is an additional remedy, not a substituted remedy. Fifthly, the Court of Justice, as I shall try to show, has consistently invalidated attempts by insurers to exclude or limit their liability to compensate victims, and has consistently treated vehicles as insured and has described them as such for the purpose of the MID, the Motor Insurance Directive, even if the policyholder is not insured as a matter of contract, or even if the driver is not insured as a matter of contract. And in those cases, notwithstanding the contractual unenforceability of the insurance benefits, European law says the source of compensation is still the insurer, not the compensation fund. And it's against that background that I will then come to Prayer and Aid, Mar Leasing and its satellites. And then as a distinct point, and I'm going to address it distinctly, there is this point about Article 18 and the direct right of action. It's perfectly clear that your lordships have absorbed what Mr. Worthington has said about that. Mr. Worthington says, well, that's only a direct right of action if you are contractually on the hook as an insurer. And that's the points that my Lord Sumption put to me. We say with respect that that is not a correct interpretation, or if necessary, it's at least not an interpretation which is act clear. So turning at last to the directive, if I can begin with recital 2 at manuscript 1025, I'll take it very shortly. It's a recital that emphasises the special importance of motor insurance to EU citizens. It's also a manifestation of the citizenship provisions in the treaty. Of course, a large measure of that is not just the sort of natural humanity of those legislating in Brussels, it's also the frequency with which there are the free movement of vehicles across national boundaries firstly happens, and secondly is essential to fundamental community principles like freedom of movement, for example, and freedom of trade between member states. So 3 is the basic insurance obligation. Each member state shall take all appropriate measures to ensure civil liability in respect of the use of vehicles is covered by insurance. And as Mr. Worthington has correctly foreseen, we emphasise that the directive throughout requires these measures to attach to vehicles, not to drivers. And irrespective as to whether or not that is not our island tradition, say with respect, that is simply neither here nor there. If we are right about the scope of the directive, then our domestic tradition must be brought in line with it, unless that is impossible, even under the muscular jurisdictions which I've identified.
You agree, presumably, that in Article 3, the obligation is to ensure that that civil liability in respect of the use of vehicles based in its territory is contractually covered by insurance.
Up to a point.
Well, up to what point?
Well, the point is this: the obligation on the member states is to take all appropriate measures to ensure that outcome. But what I will say is, where that outcome is not achieved, the directive, as interpreted by the Court of Justice, expands the liability of insurers.
Well, I can see that there are
Yes.
other provisions which deal with backup
Yes.
liabilities, loosely so called. But you accept, I think, that Article 3 itself, the first paragraph. Sorry?
Recital 3.
Recital 3, yes.
Yes.
Article 3.
Well, Article 3 is the corresponding article. They both refer to the obligation to ensure that there is a contractual liability.
Well, the obligation is to ensure that insurance policy exists.
Well, that sounds like the same thing.
Well, no, with respect it isn't, because you have to read the directive holistically, and one of the fundamental effects of the directive is it strikes down contractual barriers to the validity of the insurance. And Article 13, which we'll come to, rather like our own domestic legislation, gives a checklist of things which are specifically prohibited.
Yes.
But as we shall see, the case law of the Luxembourg Court has treated that as simply a non-exhaustive list. And as far as I'm aware, there has not been a single case which has ever gone to Luxembourg where an insurer's attempt contractually to exclude liability has survived.
Well, I dare say, but that is the mechanics by which you ensure that contractually someone is covered, because if they fill it full of exclusions, the exclusions are ineffective.
Well, I would say that what the directive is concerned with is that an insurance policy exists, and if an insurance policy exists, then the insurer is on the hook pretty much come what may. And with respect, I would say that as one goes through the directive as a whole, and still more so when one looks at some of the case law, there is a pretty profound indifference on the part of the European legislators as to whether the insurance is effective as a matter of contract.
Well, the third paragraph of Article 3 says that each member state shall take all appropriate measures to ensure that the contract of insurance also covers. So I think the implication must be that in the first paragraph, when it says covered by insurance, it must be covered by a contract of insurance.
So can you just tell me...
In Article 3...
Have we sorry, forgive me, I was still in the recital.
In Article 3 of the directive, the first paragraph imposes the obligation on member states to ensure that the civil liability is covered by insurance. Then the second paragraph, the extent of the liability, terms and conditions should be determined, etc. Third paragraph, each member state shall take all appropriate measures to ensure that the contract of insurance also covers. So plainly, when it talks about being covered by insurance, it's envisaging covered by a contract.
It legislates also for the scope of the contract. I certainly agree with that. For example, it must be extraterritorial. It must cover the whole of the European Economic Area, and it must cover both damage to property and personal injuries. And so yes, I certainly agree with that. But Notwithstanding that here there is a legislation for the scope of what is required by way of compulsory insurance, I nevertheless maintain the submission that the directive as a whole looks to the compulsory insurance as a source of compensation which goes very greatly beyond what it would be as a matter of contract. If I can return to the recitals, and recital 8 that's so it envisages that there is a presupposition that all community motor vehicles travelling in the community are covered by insurance. The national law of each member state should provide for compulsory insurance of vehicles against civil liability, such insurance to be valid throughout community territory, and to some extent we've visited that. Then recital 12 is important because it contains the obligation to guarantee insurance cover to minimum amounts, ensuring victims are protected against personal injury and property damage. There are certain caveats, but that is the thrust of it, and that's one of the core rights. But we then get to the guarantee body, such as MIB, which comes at 14. It's necessary to make provision for a body to guarantee that the victim will not remain without compensation, where the vehicle which caused the accident is uninsured or unidentified. And obviously I stress that is the role of the guarantee fund is where a vehicle is either not insured at all or not identified, and in this case we have neither of those things. And we say that's an immediate indication that national law should not require resort to the guarantee fund in circumstances which I say require resort, I underline require. I accept it can give resort as an option, but it can't require sole resort to the guarantee fund in circumstances which are wider than its prescribed role of covering vehicles which are not identified or not insured.
So you're saying that it's contrary to European law for the MIB to offer a wider cover?
No, I have to say with respect, I thought that was the very point I just eschewed in saying that what is not permitted is for European law to require the victim to have recourse to the guarantee fund. There is no difficulty at all if the MIB wanted to give everybody who suffers a road accident a golden apple, that would be perfectly legitimate in European law. But if it said because you get the golden apple you can't have recourse against the insurer, that would be forbidden in my submission. Then as 18...
Why do you say in terms of 14 that this is not a case where the vehicle which caused the accident is uninsured?
Because it is covered by a policy issued by Liverpool Victoria, which they accept that but for my inability to name the tortfeasor would require them to meet a judgment.
No, what's covered is the driver.
The vehicle's not covered by an insurance policy at all.
Well, of course, that is one of the ways in which our domestic law bifurcates from the continental law. But we say that this is a vehicle which is covered by insurance, and certainly that is the way in which the directive has been interpreted and its predecessors have been interpreted in the case law.
Well, you've obviously got, in a UK insurance context, I can quite see the logic of saying, well, what that must mean is that a person is covered in respect of the use of the vehicle, which is the way that the statute and the contracts work. If you interpret insuring the vehicle as meaning insuring a person in respect of the vehicle, then the reality is that the relevant person is not insured.
Well, that would be right if that's how you interpret it. But that, of course,
but I thought that was how you do interpret it. Surely you are saying that when the directive says the vehicle must be insured, you've got to read that in a UK context as meaning a person is insured in respect of the use of the vehicle, unless you're saying, which I don't think you are, that the whole scheme of the Road Traffic Act and the insurance regime in England, by insuring individuals rather than vehicles as such, is contrary to European law.
Well, I'm not saying that. It's with respect, it's a non sequitur to say that because we're different, it's contrary. But when you do have a system that works in forgive me, that may have sounded slightly impertinent. Well, I mean, it's potentially a non sequitur. But I mean, clearly, when you have a European system which anticipates, as all my learned friends accept, that it is vehicles which are insured, and you graft it onto a domestic tradition of it being individuals that are insured, you do risk there being gaps. And I certainly say that in this case, a gap has emerged.
No doubt you'll come to this in due course, but one of the problems is that the way you're asking us to bridge the gap has implications beyond this particular context. And it's not obvious to me that if you're right that there's a gap, it follows that the courts must allow claims and damages to proceed against unidentified defendants at large. And I'm not sure we can pick and choose.
Well, I mean, certainly on the hypothesis, that's sort of obviously addressing what I was saying was the second question is if there is a gap, can it be bridged? Yeah. And that really takes us to, as I said at the beginning, the sort of points that my Lord Sumption was putting to Mr. Worthington. And now our submission essentially is it can be because the Bloomsbury case is correctly decided. There is not an intrinsic difficulty with a judgment being entered against a person identified by description in circumstances.
These are all propositions of English law.
Yes.
I mean, what you are trying to do is to say that we've got to read the directive as requiring us to create a right against the insurer.
Yes.
But what you're trying to do is not to create a right against the insurer. You're trying to create a right against the tortfeasor, and the right that you're trying to create against the tortfeasor is not a right to damages, because such a right unquestionably exists in English law. It's a right to sue him, although you have no idea who he is. Mm. And that's rather a different kettle of fish.
I don't think that's an unfair summary. No, I mean, but of course I would phrase it in a different way. I would say that what I'm trying to fashion is an effective route to a European remedy, which all emanations of the United Kingdom, including with respect the courts, have a duty to fashion if they can. If I'm right in my interpretation, and obviously that may, with respect, be an issue between your lordship and myself. But
I mean, there's a further issue, isn't there? That I mean, the Secretary of State is not party to these proceedings. But if, I mean, you seem to be saying, well, the slant of the English law is wrong in terms of the directive. They're aimed at the wrong target. And surely, if that were the proposition, then one would want to know what the Secretary of State thought about that, because it would be his job or her job to introduce appropriate regulation under the European Act to make sure that we were hitting the right target. Not for us as a court to try and sort of sort it all out with one case without the Secretary of State here.
Well, of course, I recognise that there's force in that, and if, for example, there were this case were found to give rise to referable questions, then I mean that is a procedure in which the Secretary of State would participate. But I mean, what we are arguing here is simply that there is a relatively contained gap, because in those cases where, I mean, it's not the classic hit and run case where you can't identify the vehicle. It's not the classic uninsured case, because it's absolutely clear that if there is no insurance, then it's MIB. It is that subset of cases where you identify a vehicle and you identify an insurer, and the only thing which is stopping you bringing home the rights which we say are secured by the directive is the ability to is the ability to identify the wrongdoer. So, I mean, we're not saying that there is a sort of thoroughgoing failure in transposition. I certainly, for example, don't, as part of my submissions, to say that those cases that my learned friends have referred to and so on, like the Carswell case where it said that the untraced driver's agreement is equivalent or are necessarily wrong. albeit, as you will have seen from our recent case, we do, if necessary, say that it perhaps seems to us that Mr. Justice Hickenbottom, as he then was a little naive in thinking that an inquisitorial system is satisfactory when the inquisitor is also the compensator. I mean, in inquisitorial systems, the inquisitor is usually a neutral party, not the party that has to compensate if a liability is found. But I mean, for present purposes, we don't really need to get into any of that. Because it's not a question as to whether or not the guarantee arrangements in this jurisdiction, like the untraced drivers agreement, are inferior. It is simply that they aren't the same. And more to the point, even if they were precisely the same, or even if it could be shown conclusively that the guarantee system was better, if I'm right that European law guarantees a right of primary recourse to the insurer, then that's a right which I'm entitled to try to enforce simply because it's a right that's given to me and it's a matter of autonomous election by my client. Obviously, we say in this case, my client has perfectly rational reasons which the court will accepted for preferring the forensic route rather than the untraced drivers agreement route. Yes, I'm just reminded to say, and I think it's a point that I try to identify at the start by saying my submissions are confined to the issue of whether there is a identified vehicle and identified insurer, but not an identified wrongdoer. Obviously, in our domestic procedural law, you can only, assuming Bloomsbury is right, you can only dispense with the need, firstly, to name a defendant if there is some legitimate reason for that. And then when it comes to service, you can only get alternative service or substituted service, depending which term one prefers, if there's good reason. You can only dispense with service if there is an exceptional circumstance. So, I mean, there are further areas with gatekeepers which prevent the gatekeepers to the floodgates, if I can put it that way. I think that what it's said by MIB we're talking about here is about 1,700 cases a year or something of that sort. I mean, I'm not suggesting that's something that the court can just airily brush away. But we are not talking about Justice Cardozo's famous concern about indeterminate liability, etc., etc. Forgive me if it's pedestrian, but to return to the journey through the directive. I think I was on Article 14, and
Recital 14.
Recital 14, forgive me, my lord, thank you, I'm grateful. Recital 14, and I mean, we say that in asking whether or not the vehicle is uninsured, the question is not whether or not the vehicle is uninsured in the particular circumstances of the case, because, for example, the insurance doesn't attach to the particular user, or because even if it attaches to the user, there is some contractual term that enables the insurer not to indemnify. We say it is a much more basic question that does a policy of insurance exist which is associated with the vehicle. We say that is illustrated by the fact that the directive invalidates, as against the victim, contractual clauses which restrict the insurer's liability. And you get that in the very next recitation, recital 15. It's in the interest of victims the effects of certain exclusion clauses be limited to the relationship between the insurer and the person responsible for the accident. And the only restriction on that in the recital is in the case of vehicles stolen or obtained by violence. And in those circumstances, the member state can say somebody goes to the compensation fund instead. And then there are just a series of short points which I'll note very quickly, if I may. Recital 17, you'll see there is a reference there to an option of limiting compensation where vehicles are unidentified. Recital 18, which provides for the involvement of the guarantee fund where an accident is caused by a vehicle which is uninsured. Recital 22, which simply refers to pedestrians and passengers as the particularly vulnerable. That should be covered by compulsory insurance of the vehicle involved in the accident. And then at 24, the obligatory territorial scope, which I've mentioned. And then the first appearance of a point that I've mentioned already, point 29, insurers are not allowed to charge excesses when it comes to third-party liability. And we, as you know, we say that that is a reinforcement of the importance of making sure a claim is correctly addressed, because the guarantee fund is entitled to apply in excess, but an insurer isn't. Then at 30, we get the direct right of action, which, as I said, I'm going to, if I may, address distinctly. So at present, simply because we're voyaging through, I'll just ask the court to note it. And then if one goes forwards to 42, to recitals 42 and 43, these establish these establish what are called national information bodies. And the reason I mention it is we say that the nature of the national information bodies which must exist under European law, again, identifies or supports the proposition that the general expectation is that you proceed against insurers. And so injured parties suffering loss or injury, this is recital 42, sometimes have difficulty in establishing the name of the insurance undertaking providing insurance against civil liability in respect of the use of motor vehicles involved in an accident. And then 43, because of that, member states have to set up information bodies which make information about insurance available.
I mean, the right referred to in recital 30 is clearly a right to, it's a contractual right that must be available. Certainly it must be available on the footing that anything in the contract which limits or excludes the liability will be avoided as a result of the provisions of, in particular, Article 13. But Article 30 is concerned with enabling people to enforce a contract,
Well,
albeit a contract complying with the description in Article 13.
it's a question almost of really the sequence in which you take the analysis. I clearly recognise the language of the right to invoke the insurance contract. But the question is that a question of the right to invoke the insurance simpliciter, or is it the right to invoke the insurance contract as modified by the directive, so that some things which exclude liability as against the victim are invalidated? Now, if I'm right, and now my submission will be that it is the latter. It is when you ask, when the victim has the right to invoke the insurance contract, that is the insurance contract in light of the directive's limitations on the insurer's ability to diminish its contractual obligations vis-à-vis the victim. And if I'm right about that, then certainly in this area, there has not been an adequate transposition into domestic law, for the reasons given by Mr. Worthington. As he says, the 2002 regulations clearly only endow a victim with a direct right of action where there is a contractual right the policyholder himself would be able to enforce for an indemnity.
Is it of interest to see in recital 30 that it's talking about the right of direct action against the insurance undertaking covering the person responsible against civil liability?
Yes.
Now it's focusing on the specifics.
Yes. Well, I say there are potentially two issues here. I mean, the first is it's really a restatement of the rhetorical question I said a few moments ago as to whether or not you just look at you invoke the contract simpliciter or you invoke the contract as modified. Similarly, when you're asking the insurance which covers the person responsible, do you ask that question with reference to the contract simpliciter, namely, does this contract cover the person responsible? Or do you ask that question with reference to the prior effects of the directive in invalidating exclusion clauses, so that even though, as a matter of contract, the person responsible wouldn't have a contractual right to cover vis-à-vis the victim, the contract does cover the person responsible?
Well, that just means that the exclusion is void as against the third party.
Yes. Yes. And yes. Yes, and there is a second point of, I mean, my primary submission is that when you ask which when you ask who is is this an insurer who covers the person responsible, you ask that question having in mind the way in which the directive expands insurers' liabilities by invalidating exclusions. I mean, an alternative possibility is that whereas elsewhere the directive refers to the person responsible for the accident, I mean, here it just refers to the person responsible. And I mean, does that, for example, mean the person who is responsible for the person who is responsible for the relevant vehicle, which could be the policyholder? He's responsible for it even if he wasn't driving it at the material time. Now these are issues on which there is no jurisprudence from the Court of Justice. And certainly, I mean, if unless your lordships think that what we are contending about the direct right is so hopeless that my learned friend's submissions essentially are act clair, then it's not impossible there is a referable question as to whether or not you ask who is the person responsible, simply with reference to the contract as enacted, or do you ask it with reference to the effect after Article 13.1 has been applied to it? I mean, and certainly some academic writers in this country, I don't think they're in the bundle, but have argued that you ask who is the insurer of the person responsible, and having regard to the fact the insurer's responsibility has been enlarged by the directive, viz. Article 13, and the expansive case law of the Court of Justice, which has been decided under it and its predecessors. I think I just mentioned the information requirements. I mentioned 42 and 43. At recital 45, the injured party does not have the same right to information about the owner or the driver of the vehicle. Recital 45 says the injured party may have a legitimate interest in being informed about the identity of the owner or the usual driver or the registered keeper. But whereas the obligation to give information about insurers is absolute, the obligation to give information about the policyholder or the driver is, it seems, elective. Then, with apologies for the... sorry, I think I should just go on to over the page, recital 47. Recital 47 is really addressed to the situation where there is an insurer, but if I can put it colloquially, it's dragged its feet. So it's a very distinct scenario. But just in addressing that scenario, I do say that here again, the directive is anticipating that in all ordinary circumstances, the recourse is to the insurer. So in order to ensure the injured party will not remain without compensation, it's necessary to make provision for a compensation body to which the injured party may apply where the insurance undertaking has failed to appoint a representative or is manifestly dilatory, and where the insurance taking cannot be identified. And that is something that should be limited to rare individual cases.
You missed out the words compensation to which he is entitled, and that's reflected elsewhere in the recitals. You've got it also in 22, for example, where they're recognising that national law may not entitle someone to compensation. How does that relate to where our national law doesn't allow you to sue the driver, and therefore you don't get through to section 1?
Well, and of course is a point that my learned friends take. I mean, I would say with respect that that is a point which my learned friends are misclassifying. It is not a point about whether there is civil liability at all, and if there is, as to how the civil liability should manifest itself in terms of the quantum of the compensation. It is largely. I think it's right to say that the authorities from Luxembourg have moved on somewhat since the Farrell case, the court was shown. But it is largely the case that issues such as is there primary liability, do you have to show fault? Are there relevant issues of contributory negligence and things of that sort? I mean, those are matters which remain primarily for domestic law. But the key point is that where a right to compensation would exist against the wrongdoer, then the right against the compulsory insurer should generally be precisely the same. And that is why we say that this is an issue of community law, because there is no dispute between Mr. Worthington and myself, or any of the others of my learned friends as to whether there should be liability and what the compensation should be. It is a question as to whether or not I can get that compensation from the source that I say I'm entitled to get it from. And that, in my respect, that is a question about the effectiveness of a European right, which is to get the source from the insurer, and it is not an issue of liability or quantum, if I can put it that way. Yes. Ms. Had points out that, for example, in recitals 10 to 11, there are limited derogations in returns of things like cars with diplomatic plates and so on. But in general, in general, what we are here concerned with is not whether there is a right to compensation. There is a right to compensation. If I could name the wrongdoer, I would have that right. And domestically, I'd be able to enforce it against Liverpool Victoria. What we are here concerned with is the fact that, if I'm right, that I have a right of compensation against Liverpool Victoria, there appears to be difficulties in enforcing that right domestically, and that's what I'm identifying as the gap. And that, in my submission, is a question as to the effectiveness of a European right. Yes. Recital 49, I think, is next. It's another point that's been picked up in the argument. Subrogated claims can be excluded by the compensation body. They can't, and it's not just subrogated claims, it's subrogated claims or their analogues. So claims in respect of social security bodies, for example, and the MIB excludes claims really in respect of everybody, in respect of even well-wishers, it seems, who give money to a disaster fund or something of that sort. There's no obligation that the MIB can take advantage of that in a way that a tortfeasor would not be able to under very familiar principles of res inter alis acta or behind the curtain or whatever modern idiomatic translation you want to give that hallowed tag. That's another significant difference as to why we say that it can't be right to shepherd victims into making claims against the guarantee body in circumstances where their European right is to go against the insurer in preference if they want to, because the guarantee body's obligations are different. I mean, the guarantee body doesn't have to meet claims to the benefit of other insurers. There is no equivalent exception for compulsory motor insurers. And that's an important right to victims because it's, as we say in our written case, subrogated claims are ubiquitous in this area, not just by other motor insurers, but by legal expenses insurers, by private health insurers. Very common, somebody will have physiotherapy after an accident and call on their private health insurance. I mean, they don't get that back. Their premiums may go up. MIB puts in some evidence saying, well, it's very much to be hoped that our members wouldn't do that. It's not just about their members. And again, another example, which in my submission is a wholly real-world example, which we posit in our case, the insurance policy that has a limit of indemnity, an aggregated limit of indemnity. If you've had to denude your private health insurance for £1,500 worth of physiotherapy after an accident, or because you suffer some anxiety, you get some counselling. And then later, and then subsequently, you're told that you've got signs of cataracts and you don't want to go on the NHS waiting list and you want to get your cataracts lasered through your private health insurer. Your limit of indemnity is correspondingly reduced, and you might not be able to afford to do that, or you might have to pay the difference. I mean, these are real-world points in my submission, and this has got nothing to do with the question as to whether or not the sort of Carswell question, the road piece question, where what was being said was that the untraced drivers agreement is inadequate under European law. I mean, European law allows MIB to give itself exceptions which a motor insurer is not allowed to give itself. And I've mentioned two of them, the excess and the subrogated claim. So those are perfectly legitimate reasons why a victim should not, in our submission, be thrown onto MIB if they've got a right not to be. And obviously, I appreciate I've got to make good the proposition that in this context they do have a right not to be. But if I'm correct in the proposition that they have a right not to be, then in my submission it is clear. And with respect, I say this falsifies really everything that MIB says about how wonderful the untraced drivers agreement is. Even if one grants all of that, the untraced drivers agreement contains exceptions which European law allows the MIB, but it would not allow anybody else. And that's why they are not equivalent remedies, because it's an apples and pears type situation. Now, I think I obviously have to be a little bit brisker. Can I, just before I leave the recitals, can I just mention recital 53, where it's impossible to identify the insurer of a vehicle? It should be provided the ultimate debtor is the guarantee fund. And again, I say that's all of a piece with the submissions that I've hitherto
We
made.
actually ought to be looking, surely, at Article 10 for many of these things. I mean, the recitals tell us why we've got Article 10, but Article 10 is the relevant legislation.
Well, obviously your Lordship is quite right that we need to look at Article 10, but equally your Lordship knows very well the jurisprudence from the Luxembourg Court that emphasises the need to interpret the articles in light of the policies which are more clearly stated.
Well, there's no inconsistency, but if we want to know what the actual obligation is, we've got to look at Article 10.
Well, if that's your Lordship sort of indicating to me a way in which I might usefully pick up the pace, then I'm very happy to do that. So let me come, my Lord, to the articles. Article 3 is we somewhat anticipated because I was taken to it by two members of the court. That's the compulsory insurance obligation. We then get to chapter 4, which is at page 1033. And the heading will be noted, compensation for damage caused by an unidentified vehicle or vehicle for which the insurance obligation provided for in Article 3 has not been satisfied. Now, we say, and with respect, we say it forcefully, I hope, well, that's for you to decide, not me. But I mean, we say that this clearly is a vehicle which has been identified. That surely is common ground, and it is a vehicle for which the insurance obligation in Article 3 has been satisfied. This is a vehicle in respect to which it's common ground. A policy of compulsory motor insurance was issued and attached to its use, which satisfied the requirements under the directive. Now, here we get the obligation to set up the compensation fund. Yet again, we see the phraseology of it covering damage to property or personal injuries caused by an unidentified vehicle, or a vehicle for which the insurance obligation provided for in Article 3 has not been satisfied. That's a vehicle to which insurance does not attach. And then you have some of the excesses and so on, which I have pointed to, and the exclusions, which, as I've argued, wouldn't be available to a motor insurer. For traversing the two columns, you have the right of the compensation fund to make its compensation subsidiary to, for example, Social Security and other insurance companies. That's what authorises, of course, the exclusion of subrogated claims. You're not allowed. You're not allowed to make compensation contingent upon the guilty party refusing or being unable to pay. But it isn't actually said, for example, that you can't say you have to go to the guilty party first, and if he or she doesn't pay within a certain number of days or something like that. These are some limitations. And then at 3, you'll see member states may limit or exclude the payment of compensation by the body in the event of damage to property by an unidentified vehicle. But where the body has paid compensation for significant personal injuries to any victim of the same accident in which damage to property was caused by an unidentified vehicle, there's an excess not to exceed €500. And so, I mean, these are some of the ways in which perfectly properly and in accordance with European law, bodies like the MIB can limit their liabilities to victims in a way that a motor insurer couldn't. And then another clause, another article which we've anticipated to a significant extent is Article 13 exclusion clauses. this specifically, the member states must take all appropriate measures to ensure that certain statutory provisions or contractual clauses contained in an insurance policy are deemed to be void vis-à-vis victims. And the specific areas which are identified are unauthorised drivers, unlicensed drivers, and persons who are in breach of technical requirements. And that, of course, would be things like bald tyres or vehicles that are carrying loads for which they weren't designed, or vehicles that have got low tyre pressures and things of that sort. And there is then a limitation that allows exceptions to be invoked against unauthorised drivers if they entered the vehicle when they knew that the vehicle was stolen, and the insurer can prove that.
Sorry, where do we find that last one?
It's the bottom of the first column of Article 13.
Thank you.
And then at 2, where a vehicle is stolen or obtained by violence, then in those circumstances, the member states can properly transfer the liability to the compensation fund rather than the contractual insurer. And then at 3, there's an invalidating clause concerning a cover for passengers in cases where drivers are intoxicated. Then Article 17, again I preempted this, this is in distinction from the position of guaranteed bodies like MIBs. Article 17, insurance undertakings are not allowed to levy excesses. Article 18, the right of direct action, that obviously is something we've anticipated. And then in Chapter 7, the heading of Chapter 7, settlements of claims arising from any accident caused by a vehicle covered by insurance, as referred to in Article 3. And so again, there is a reference to vehicles which are covered by insurance, and that is the terminology that's used in Article 19 as well. And then lastly, in the articles, we have the fleshing out of the information requirements, which I mentioned in the recitations. And the court gets that in Article 23, which traverses pages 1036 and 1037. And you'll see that requires a register of 1, registration numbers, well, we had that in this case. 2, the policy number, we had that in this case. And 3, the insurance undertaking covering the vehicle, well, we had that in this case. And at the bottom of the first column, there's an obligation to assist entitled persons, that's victims in essence, to be apprised of the information that's there listed. And then over the page at sub-article 3, member states should ensure that the injured party is entitled for a period of 7 years to that information without delay, including the name and address of the insurance undertaking and the number of the insurance policy. But at 4, the information centre should provide the injured party with the name and address of the owner or usual driver or registered keeper of the vehicle if the injured party has a legitimate interest in obtaining this information. I submit that these provisions are instructive, first of all, both in the general proposition that where there is insurance, the directive anticipates it's the insurer that pays. That's why there's this obligation to have all this readily accessible information about the policy number, the insurance undertaking, and so on. And to have a searchable database of registration numbers so you can identify the insurance undertaking. And I say it will also be relevant when we come to conclude on the question of the scope of the direct right of action.
I mean, you're taking us through all this, but actually your case is relatively simple, isn't it? I mean, you're saying that if we look at Article 10, that has no application to a case like this because it's not an unidentified vehicle.
Yes.
And it's a vehicle which is covered by insurance.
Yes.
Therefore, we're outside Article 10 altogether. So hang on a second. I'm trying to understand your case. And then we go to Article 18, and we have the simple duty to ensure there's a direct right of action against insurance.
Yes.
That's what you're saying.
If I can be entirely blunt about it, and if I hadn't detected a measure of scepticism from the bench as to the propositions I was making, then yes, I could have stated it as...
I mean, the oddity for me is that this point hasn't come up before, ever, in these proceedings or any other. I'm not quite sure why it's sort of something emerged now.
My Lord, I understand that it was only in 2017, after what the first motor insurance directive predated our accession to the community. I think it's from 1972. It was only in the De Segura's case last year, 2017, that the court, at least that's when it's reported, it might have been decided in 2016, that the Court of Justice said, notwithstanding what Article 13 says, Article 13 clearly doesn't say, we also invalidate any exclusion clauses based on non-disclosure. But just in 2017, the Court of Justice, and I'll take you to it in a moment, the Court of Justice says, the directive also forbids insurers from being, as against the victim, from being able to avoid cover by voiding policies for inception through non-disclosure or through wanting.
You're saying a case report in 2017 has changed the perception of all this?
Well,
We're not concerned with these special defences. We're not concerned with exclusions, which are, as we've agreed, are ineffective. We're not concerned with avoidance. I mean, I appreciate there has been an attempt to avoid, but nobody's suggesting that that is relevant for the purpose of this dispute. What we're concerned with, essentially, is a contractual liability, which, if it doesn't exist, although it should, causes the MIB to step in.
well, we are. The reason I am inviting the court's attention to the exclusion of contractual liability is because, or the exclusion of the ability to rely on contractual defences as against the victim, both those expressly identified by Article 13 and also by the much wider range of contractual exclusions that have been subsequently invalidated by the Court of Justice, is to say that provides in our submission strong support for two propositions. The first proposition being an overarching policy that when there is where an insurance attaches to a vehicle, the insurer will be the source of the compensation.
Well, we have to start, don't we, by asking what is meant in a UK context by an insured vehicle. There seem to be two possible solutions. One is that by failing to provide, in English law, for the compulsory insurance of vehicles as opposed to people using vehicles, the UK is for that reason in breach of the directive. I don't think you're saying that. The only alternative is to say that in a UK context, what is meant by an insured vehicle is a vehicle in respect of which a person is insured. If you take that view, then the relevant person was not insured in respect of this vehicle.
Well, I mean,
you seem to be submitting that the unspoken ethos of this directive is that the insurer must be liable for everything, but that is clearly not consistent with the reference to the contractual terms which appears throughout this directive, notably in Articles 3, 18 and 10.
yes, well, the first thing I would say is I'm not, with respect, sure it's right to be asking what does this mean in a UK context. I mean, we have to be asking what are the obligations which the directive places upon the UK along with other member states. And
but
that
you're
doesn't
not saying,
differ.
as I understand it, that the UK is in breach of European law simply by allowing people to insure persons in respect of the use of vehicles as opposed to the vehicle as such.
Well, I certainly don't say they're necessarily in breach of European law, but I mean what I am saying is the significance of the significance of both the legislation in Article 13 and the case law around exclusion clauses is they show very well that once an insurer is present, then the insurer is on the hook for the compensation, quite irrespective of whether or not it is on the hook contractually. And that appears to be the ultimate area of difference in this colloquy between your lordship and myself. But I mean, that is what I say is the case. It is, with respect, Article 13 ejects the question as to is the insurer contractually liable. As vis-a-vis the victim, the insurer must compensate come what may. And that, in my submission, is consistent with our broader proposition that the directive endows people like my client with a right to sue an insurer if they can identify if they can identify one, they are not to be thrown onto the compensation fund as the fund of the last resort. And en passant, a very good reason for not throwing them onto the compensation fund as a fund of the last resort is because the rules by which the compensation fund compensate are different from those by which insurers compensate, because inter alia, insurers can't charge an excess and insurers can't exclude claims to the benefits of third parties such as fellow insurers and well-wishers and social security bodies and credit hire companies and credit repair companies and all the other paraphernalia of 21st century motor accidents.
Can I just come back? I mean, in Article 10, in relation to this vehicle, this accident,
Yes.
are you saying it was or was not a vehicle for which the insurance obligation provided for in Article 3 has not been satisfied?
I'm saying it was a vehicle for which the insurance obligation had been satisfied.
Had been satisfied.
And that is the way in which it would have been treated by our domestic law if we could have identified a wrongdoer, because we would, let's assume...
So how does the MIB come into it then?
Well, the MIB comes into it because my learned friends are saying the MIB should be the source of the compensation. That is what I'm saying is the fallacy here. Now, obviously, if they are right that there is a procedural lacuna that prevents me from exercising what I say is my union right, then MIB does come into it as the fund of the last resort. But, that ought not to be the position. But that's why my Lord, if I may respectfully say so, I think puts the finger on it. The question is and it may be the distinction which is emerging in the questions which are being put to me by my Lord Sumption. We say that this is a vehicle in respect of which the compulsory insurance obligation has been satisfied by Liverpool Victoria's policy. And that is why it cannot be right, as a matter of European law, that we are being thrown instead onto a guarantee fund, which, as it happens, provides a lesser measure of compensation. And nor is it right, in fact, because of its particular provenance as part of the motor insurance industry, the MIB is here advocating, we say, for its fund to be applied in circumstances where European law says it doesn't need to be, because it's meant to be a fund of the last resort for cases where there is not an identified vehicle at all, or a vehicle which is identified but with no insurance having been identified as attaching to it. And again, when my Lord Sumption is saying to me, well, these Article 13 and the case law which I've been referring to without having taken you to, it's just irrelevant. In my respectful submission, it isn't. It is not precisely because it shows the directive regards somebody as covered by insurance. And by somebody, I mean a victim's claim as being covered by insurance, irrespective of whether or not the insurer has any contractual obligation to pay the policyholder. Vis-a-vis the victim, that is still an insured case. And that's the whole point of having compulsory motor insurance. It's the whole point of having the Article 13 express invalidations of exclusions. And it's the whole point of the muscular, as I've described it, jurisprudence of the Court of Justice, which has expanded the exclusions far beyond those which are actually expressly legislated for by Article 13. Because, as I have said, for example, in the de Seguros case, Portuguese law, just like our domestic...
Have we looked at that?
No, and I'll take you to it. Maybe that would
because you're saying this was a great case which suddenly revealed all.
Well, I have to be frank and say, I look back at what I said to the Court of Appeal. In fact, I did take the Court of Appeal to some of these cases. I took them to Churchill, for example. But I certainly accept that it's looming far larger here than it loomed there. And I readily accept it was me reading the de Seguros case that triggered... maybe that my Lord Sumption would say this flight of fancy.
I didn't say that, but it's certainly a brand new case, which is not prefigured in the judgments below.
No, that of course is entirely fair. If I'm going to take your lordships to the case law, which I've tried to do, because of course I must try to finish this one of my submissions by 3:30, and then I can deal quickly with some of the other points remaining. Quite a lot of those are presaged in our written case. And certainly so far as the Road Traffic Act is concerned, I think given the time I shall just have to invite your lordships to consider what we say about that in our written case, which essentially says that the majority in the Court of Appeal were right for the reasons they gave, and so perhaps that lets me cut through that. So turning, if I just can, briefly to the authorities. I know I've mentioned the De Seguros case, but I wonder if I could perhaps start with a case called Kasonka and Magyar Alam, which is at tab 31 of the second volume, which is manuscript 1417. So it's a decision of the First Chamber. And it's something of a sui generis situation. What happened in this case? In this case, is the claimants are insured by, there is motor insurance, the motor insurer becomes insolvent, the claimants therefore have to pay damages to victims out of their own pocket. And they brought a Frankovic claim against the Hungarian state because they said that the compensation fund should also cover cases where insurers became insolvent. And the First Chamber said, no, that was a misreading of the directive. But it's in the course of that they stress that the compensation fund has a role that's strictly limited by the terms of the directive. And so the narrative in the case begins at page 1425 at paragraph 22. So let me in fact start at 23. So they make the sort of traditional teleological type points about their approach. In 24, they stress the importance of having an insurance obligation. The key passages are probably at 29 to 32. And given the time, may I pause whilst the court reads 29 to 32?
Yes, sir.
So 29 reiterates the language of the directive. 30 has the last resort terminology. It's 31 to which I particularly draw attention, where it's said by marginal. No, there's not a marginal lettering on this, forgive me. It's about half a dozen lines up. They refer to vehicles for which the insurance obligation provided for in the directive has not been satisfied. That's to say a vehicle in respect of which no insurance policy exists. Such a restriction is explained by the fact that Article 3.1 of the first directive requires each member state to ensure that every owner or keeper of a vehicle normally based in its territory takes out a policy with an insurance company for the purpose of covering up to the limits civil liability arising as a result of that vehicle. Viewed in that light, the very fact that damage has been caused by an uninsured vehicle attests to a breakdown in the system where the member state was required to establish and justifies the payment of compensation by the national body. So, I mean, what is here we say is the framework anticipates that the system is meant to have an existing insurance. Whether the system is broken down so there is no existing insurance, then you look to the compensation fund as the body of last resort. But those are, in our submission, the limits. And that, we say, is reiterated in the De Seguros case, which I've mentioned. That is at tab 35, which is manuscript 1543.
Memory stick, I'm afraid.
Oh, memory stick. Oh, okay. Sorry, I thought it was. I thought it was a slightly.
We're not quite that old-fashioned.
No, okay. But it's a nice thought. It sounds more elegant. Memory stick. Okay.
1543, did you say?
Forgive me. So MS 1543. So what we have here in the De Seguros case, it illustrates 2 points. So the first, the breadth of the invalidation, if I can call it that, but secondly, reiterates the fund of the last resort. Before I introduce the case, can I just, for your note, mention the fund of last resort is reiterated at 35, but it essentially is a recapitulation of what's said in Kasonka. But at 35, they say payment is designed to be, by the guarantee body, is designed to be a measure of the last resort, only for cases in which the vehicle that caused the injury or damage has not satisfied the requirement for insurance in Article 3, that is to say, it's a vehicle in respect of which no insurance contract is in place. Such a restriction is explained by the fact that member states must ensure that there is an insurance contract in place. So it's really the same analysis, as you might expect, in the Kasonka case. The way it works is member states must insure insurance. If insurance is there, the insurance compensates. It's only if the system is broken down and there isn't insurance that you have recourse to the guarantee fund. But the other point about this Fidelidade de Seguros case is it also illustrates what I've called the muscular way in which the Court of Justice has gone about expanding the relatively short menu of forbidden exclusion clauses in Article 13. And just to try to make that good, we'll here see some principles of familiarity from our domestic law about the contractual limits on insurance. Because if I can take the court to paragraph 12 of the judgment, that's at page 1548. It deals with 2 articles of the Portuguese Commercial Code. Article 428 essentially replicates our rule that insurance will be void if there is no insurable interest. And you have that in the first indent under paragraph 12. That's Article 428. And then Article 429 replicates our domestic principles about material non-disclosure or material misrepresentations, again leading to avoiding of the policy. And of course, in our domestic law, in the very areas which we are traversing, Section 152 of the Road Traffic Act, if an insurer moves quickly, as the law stands, does allow an insurer to escape its liability under the Road Traffic Act by getting a declaration it's entitled to avoid. Now, in light of that case, the government has accepted that Section 1152 is incompatible with European law and needs to be amended. And the reason for that is precisely because in this case, notwithstanding the seemingly narrow or narrow-ish scope of Article 13, in this case, the court held the directive also forbade victims going uncompensated by the insurer in cases of no insurable interest or void policies because of misrepresentations and non-disclosures. And really, one has that between 21 and 28, which is at page 1550.
Remind me, where do we find the government's acceptance?
That is it's recited in a case called Road Peace, which was decided in the High Court earlier, I think last year. I will just wait for one of my ventriloquizers to give me the reference, if you'll forgive me.
Well, we can come back to it.
Yes. Well, I was pausing anyway because I think some of your lordships are reading. So I suppose the nub of this really is 27. It must be held the fact the insurance company has concluded the contract on the basis of omissions or false statements on the part of the policyholder does not enable the company to rely on statutory provisions regarding its nullity or to invoke that nullity against a third-party victim so as to be released from its obligation under Article 3.1. So the policy is treated as a subsisting Article 3.1 policy, even though, as against the policyholder, it was hopelessly void, offending both the principle of no insurable interest and the principle of material omissions and misrepresentations. And perhaps, again, in the context of the debate that I've been having with some members of the bench, it's perhaps also instructive to see how they deal with a related point in paragraph 29, where they say that the fact that a vehicle is driven by a person not named in the insurance policy relating to that vehicle, i.e. that is driven by a person who is not himself insured, cannot, in view in particular of the aim pursued by the directives of protecting victims of road traffic
Sorry, which paragraph are you reading
29, my lord.
Thank you.
Cannot support the conclusion that the vehicle is uninsured for the purposes of, in that case, Article 1.4. So I mean, and with respect, I do say this goes some way to answering some of the points that have been put to me. At 29, and this is said in other cases as well, but I mean, here is the only one I'm going to have time to take you to. They say in terms that a vehicle is not to be treated as uninsured simply because it's being driven by an uninsured driver, if I can paraphrase it in that way.
And that is presumably assuming that the vehicle is being insured, but that there is an exclusion or a limitation to certain drivers.
Yes, as I recall, this was a case where the insurer had been misled as to who the habitual driver was, in the hope of getting a lower premium because of his age, because of the I mean that is I think that's right. I can't be absolutely right, but I think that's the gist of it. Can I interpose the reference that my Lord Carnwath asked for? My Lord, the road peace case, and for those of us who are using the papers, it's Bundle 2, tab 27. The paragraph number is paragraph 70, and the MS number is page 1316. Thank you.
The Churchill insurance case at paragraph 29, was that a British case?
The Churchill case, as reported, contains a decision of the Court of Appeal of England and Wales, and also a decision of the Court of Justice. And so it's where precisely your Lordship was looking at when you put that question to me.
Is that Wilkinson and Fitzgerald?
Wilkinson and Fitzgerald. It's also referred to as Wilkinson and Churchill Insurance. That's tab 30. I'm so sorry, my Lord. Did you? Can I ask again which page number that your Lordship was on so I can answer that question?
No, I was just looking at paragraph 29 of the Seguros case.
Oh, yes, that is a
which
reference
refers
to
to
the decision
Churchill,
of the
and I
Court
just
of
wanted
Justice.
to get the cross-reference.
Yes. And that's at MS 1380.
Thank you.
Is it coming to this, that the vehicle is not uninsured within the meaning of the directive, unless there is nobody who's rung an insurance company and said, please put me on cover, and the vehicle I want it relating to is this vehicle?
Well, we say it's not uninsured within the meaning of the directive, unless there is no policy of insurance attaching to it.
Yes, and that's so even if it's driven off by a thief.
Well, and I think it's common ground. I mean, in this case, for example, if the car was stolen and the thief had been apprehended, Mr. Worthington and Liverpool Victoria would accept that they were on the hook, if I can continue using that colloquialism.
I mean, I'm looking at the paragraph 40 of the Churchill case on MS page 1372, which seems to say something somewhat different.
Well, look, will you forgive me? I was being passed a notice you began speaking, so I didn't quite get the reference.
I'm looking at paragraph 40 of the Churchill case,
yes,
which is what is referred to at paragraph 29 of the
yes,
Portuguese case. It doesn't quite correspond to the summary. Put it mildly. I'm sorry, I've got, forgive me, I'm looking at the Advocate General and,
It's 1382.
yeah, no, in that case, the point may well be a bad one.
Yes. The Churchill case is another case where the Luxembourg court found a restriction on an insurer's liability to be inconsistent with European law, even though it was not a restriction which fell within what is now Article 13. And in fact, I mean, given the time, I'm not sure I can really do a great deal better than this. But I mean, for your lordship's note, when Mr. Worthington asked, referred to the case of Delaney, and I do apologise if we hadn't made it clear to him why we added it to the bundle. I certainly had intended to, and I'm sorry for the omission. But the reason we've put the Delaney case in, that is tab 51 of the supplemental bundle. Is that Lord Justice, it's a relatively recent decision of our Court of Appeal, Court of Appeal of England and Wales, where Lord Justice Richards, if I may respectfully say, has an extremely useful synthesis of the authorities of the Court of Justice, up to the point that case was decided. And again, for your lordships and your ladyship's notes, because if I'm to deal with the points that are remaining, I can't take you to it. Paragraphs 14 to 25 of that case really summarise the long history the Court of Justice has in our submission of interpreting the liability of motor insurers under the directives as extremely wide, and far wider than one might think if you only read Article 13.
Which flag is Delaney?
It should be Article 51 of the supplemental bundle, my lord. Is that spiral bound? Yes, it's a spiral bound bundle, my lord, that may not have it.
I've got it.
Page 22.
And the paragraphs that you specifically directed us to is...
1425, I think you said.
Thank you.
This is Mr. Justice J.
No, I think that was my learned friends. I invited you to the judgment of the Court of Appeal, beginning at page 60. It's under the heading, the case law and the directives. And it's, I think, 14 through to 25, which is at page 66. So it's quite a lengthy exposition of the case law. And my lord, really, I said that I would develop the point about the direct right of action discreetly. I don't have time to do that, but fortunately preempted a lot of what I said in questions to my Lord Sumption. But in asking, going back to that question I posed earlier, as to when the directive says you have a direct right of action, is that a direct right of action against an insurer that is on the hook contractually? And I said, well, that might mean one of two things. That on the hook contractually, you just look at the contract, or on the hook contractually, once you've looked at the way the directive modifies the contract. And I submitted it was the latter. And as I submit, the authorities I've just summarised show, the directive modifies contractual responsibilities very extensively indeed, as explained by the Court of Justice. And I also say treating the case as covered, the liability of the person responsible being covered by the insurance. That again has to be read against the background that the case law treats the car as covered by insurance, even if the individual user is not insured, and that's the passage I showed you a few moments ago. And just generally on that point, we do say that it would be very surprising indeed if the directive, when it endowed the claimant, when it endows victims with direct rights of action, it would be very curious indeed if that endowment was concerned with whether or not, as against the policyholder, the insurer is on cover. Because it's a right that is given to the victim. As we have seen, the policy of the directive is to give the victim a host of rights that the policyholder wouldn't have. The direct right of action is given to the victim to allow the victim to vindicate his or her rights, not to vindicate the policyholder's rights. And so why would the the directive be endowing victims with rights which are trammelled by a contractual liability to the policyholder, which the directive themselves invalidates? I mean, it would be an extremely curious way to go about matters. When the direct right of action is obviously there, to put it crudely, to allow claimants to cut through the intricacies of suing named individuals, particularly in circumstances where there's a specific reference to cross-border transactions. And it has to be also looked at in the context of the information centres, which are there to give you information about insurers, surely to allow you to vindicate that right of direct action by making it very easy to find out who the direct right of action should be exercised against. So really, those are the reasons in a nutshell, and obviously we go into it in a bit more detail into our case as to why we say there is a direct right of action. The directive without the direct right of action endows claimants with a right to compensation from an insurer where insurance attaches to a vehicle. And that is a right which, on my learned offence analysis, I'm unable to enforce domestically. And in any event, we say it endows victims like my clients with a direct right of action against an insurer, which is not contingent upon showing the insurer has a contractual liability to its policyholder. And if I'm right about that, how does one deal with it? The principles of consistent interpretation, we cite the Pfeiffer case, which I suspect will be familiar to your lordship, and we quote your lordships, and we quote the relevant passage in extenso in our written case, and I'd respectfully invite the court to refresh its memory of that during the reservation of judgment. They do show it's a very expansive jurisdiction indeed. The court, it's not just about strained construction, it is about resorting to the entire palette of legal tools that are available to a national court, which of course includes, in that rather ugly term, reading down legislation. But it also includes making procedural innovations where necessary to give community rights effectiveness. And exercising the discretion of the court where it has a discretion in a way which tends to validate rather than to invalidate those rights. Now, if Bloomsbury is correct in our submission, there is no difficulty at all, if your lordships are with me thus far.
Well, we say there's no difficulty at all. I mean, on any view, what the Court of Appeal held wouldn't provide you with a direct right of action of the kind envisaged by Article 18 and Recital 30, but but you're saying effectively it's the best that we can cobble together.
I mean, I appreciate that I can't. I can't just invite the court to sit under a palm tree on a point like this, and there has to be some rigour to it. So, but in part of that broad palette of the court has to paint with in this context, in my submission must relate not just looking at matters in a purely black letter way, but just looking at very well settled principles within its jurisdiction. I mean, it is an absolute commonplace that in cases like this, before judgment is obtained, the culprit is the first defendant. You give notice under the Road Traffic Act to the motor insurer. That's a compulsory part of the regime. You have to give notice within 7 days of commencing proceedings, otherwise the motor insurer is enfranchised from liability. The motor insurer at that point joins the proceedings, and in the real world, it is the party which defends them. I mean, it plays a very full part in the proceedings. So in my respectful submission, for my learned friends to say, well, on a strict jurisprudential analysis, it's not a direct right of action because all it gives rise to is the judgment, which you then need a new action to enforce. That is simply not the way the matters work in this jurisdiction. And that's not how they work now. This is not a request for procedural innovation. The insurer is given notice and it joins the proceedings at the outset, and it is a party to them, it defends them, it is heard, it is legally represented. Usually the culprit, him or herself, is nowhere to be seen. Well, of course, we don't have a culprit here, but it wouldn't be different if Mr. Hussein, who was originally named as the first defendant, was still first defendant. It's a sort of Bateman cartoon scenario of the first defendant that turns up to the assessment of damages in the liability trial in general.
I wonder.
Yes.
Well,
and so if I can,
this is raising a different point, but I just wonder. You're saying, I mean, effectively, there is no such thing in English law as a right on the part of a victim to invoke the insurance contract in these circumstances where he's not contractually covered.
No.
And to claim against the insurance undertaking directly. So we're not, on any view, going to achieve what Recital 30 and therefore I presume the directive requires. But you're saying the nearest approximation to that could be managed would be to allow what the Court of Appeal allowed. Now, if one of the problems with that is that you are allowing an order for damages to be made against a person who is alleged to be a tortfeasor but has had no opportunity of taking part in the proceedings, I just wonder if that's even compatible with the EU Charter.
Well, I mean, what I would say to that is I mean, firstly, it is in a sense an invocation of the insurance contract. I mean, when you take into account the way in which the way in which the Road Traffic Act works once we come home to our domestic legislation is it treats the contract as covering the whole world. And it's under that fiction there's any judgment obtained in the proceedings, to which, as I've said, the insurer will be a party throughout and participate in, is a judgment that will be enforceable against it. And that, in my submission, it's not a sort of DIY Heath Robinson attempt to create a direct right of action. It's something that is very close to one, or is one. Yes, I mean, it's like a type of estoppel where an insurer can't avoid liability in the circumstance under its contract. So, I mean, to some extent, we go quite a long way to allowing the invocation of the contract. What's preventing my client invoking the contract here is the inability to get the judgment, which is the inability to name. Now, that obviously takes me to your Lordship's last point, which is, well, you know, can it be right to get a judgment against someone? But I would make 2 points about that. I would say, firstly, the reason why we can't name him is because he, in breach of the criminal and the civil law, concealed his identity and absconded. But secondly, if in due course the proceedings come to his attention and there's an attempt to enforce a judgment against him directly, and he has mitigating factors to justify his conduct, he would obviously be able to apply to have the judgment set aside. I mean, one might suspect that in the vast majority of cases, A, the scenario would never arise, and B, if it did arise, he would be on a bit of a sticky wicket, but the possibility at least exists. And the commercial reality of this, just as my Lord Sumption said, well, the Bloomsbury case was really all about getting an injunction against the newspapers, and as the Court of Appeal said in the Abbey National Solicitors Indemnity Fund case, well, this is really all about getting a judgment against the Indemnity Fund, which is an insurance company in an important position protecting the public. Well, this is that case. This is all about getting a judgment against an insurance company which does fulfil a role which is extra contractual under the directive as a protector of the public, as a protector of victims of motor accidents. And that's simply the price that they carry as those who have issued insurance in this jurisdiction. I really have almost no time left. But
just before you go on, I mean, I must say, until you rose to your feet this afternoon, I had no idea, at least I hadn't registered the fact that the European dimension was going to become the main focus of this case. Certainly when we granted permission,
yes,
we didn't know that. And of course, it wasn't your application. But you then resisted strongly the idea that the MIB should be involved because you didn't think they had a separate interest. But the way you developed the argument is actually, now this is the whole focus of your case, that really the whole scheme in this is actually doesn't really comply with the European system as we understand it to be since Seguros. And I'm just a bit troubled that we may not be getting all the help we should be, as how this affects the MIB's position, or indeed the Secretary of State's position.
I mean, obviously I take your Lordship's point about the Secretary of State, which your Lordship's put to me already. I mean, all I can say is the provenance of this is that, as I said, there was actually more debate about the European dimension before the Court of Appeal.
Well, I'm concerned that the papers have come to us. As far as we're concerned, this was developed in detail for the first time, I think, in your respondent's case, dated 30th of October.
I mean, Yes,
a couple of weeks ago.
We indicated we proposed to rely on the De Seguros case in our objections to leave. In the light of that, it was common ground between Liverpool and Victoria and ourselves that was a point that needed to be included, and it was included by agreement in the agreed list of statement of facts and issues. And precisely because we recognised this was a development of our case and a considerable one, that we, my learned friends and myself, agreed that the respondent would serve a case on the European aspect first, and my learned friends were not required to anticipate our case on that whatsoever in their written case, but serve a supplemental case in response to it. And that, of course, is precisely what happened, and that was with the approval of the registrar. So that is the history of it. And certainly as a result of that, MIB has been in a position to say, or we say it's been in a position to say what it wants to say. Or if it hasn't, that's partly its own responsibility for some reason indicating it was going to apply to intervene in February and then not getting around to making its
Yeah, well, then let's go into all that. I'm just putting the point. I'm concerned that we have all the information we need and all the assistance we need.
Yes.
And I've just raised the point.
Yes.
Before you sit down.
Well, my Lord, I obviously accept that there has been a substantial changing of the parameters of the argument since the Court of Appeal. All I can say is, as between the parties to the appeal, that has occurred by agreement and without objection.
No, I don't deny that.
Yes, and obviously, your lordships, your ladyship would appreciate that if there do appear to be arguable EU issues, that is something the court itself has an obligation to consider because of your own obligations as emanation of the United Kingdom. And in particular, as an ultimate Court of Appeal. And
you don't need to tell me that.
No. I mean, if we come to the view that we would benefit from an intervention by the Secretary of State, it's not too late for that to happen after this hearing. One of the advantages is these hearings being recorded.
Yes.
Somebody can come to the discussion late and put in perhaps written submissions if so advised.
I hope I don't speak unfairly for all parties at the bar rather than just myself when I say that when the time estimate of a 1 day was set, that was, I think that has challenged us even without the Secretary of State here, and we have all cantered in places. And so if your lordship was minded not to treat today's case as final, even final domestically, then that obviously is not something I could possibly make representations against.
No. Well, I think if at the end of the day we decide we need any further submissions, I think we would invite them in writing. But we're not doing that at this stage.
No.
We'll discuss where we are.
I understand, my lord. Forgive me, if I were Mr. Worthington, would just indulge me just for a few more moments. I haven't really addressed, sort of square on, the points that Lord Sumption put to my learned friend. I'm going to just do it in a few words. What I say is the Bloomsbury case demonstrates why these were rules of practice, not rules of substantive law. The civil procedure rules, which are delegated legislation under the Civil Procedure Act, do in places endow an express power to issue process against parties who are unknown. One has it in Part 53, for example, that deals with trespassers. One has it in Part 8. The discretion under the overriding objective is very broad, and it is supplemented by the court's power under Part 3 to make any order which furthers the overriding objective. The language of the practice directions is directory rather than mandatory, if that's not an excessively old-fashioned terminology, and it does use words like should. And I think that though we looked at Part 16. Part 6, I won't ask you to turn up because it's not fair to Mr. Worthington, but Part 16, practice direction says in terms the full name of the defendant where it is known. And so in my submission, the broad discretion which has been exercised in Bloomsbury and its satellites, which has included, as all my learned friends agree, judgments for damages having been entered, albeit as ancillary usually to defamation or blackmail cases, is a discretion which your lordship should find indeed exists. And if you find it does exist, then for the reasons I've given about the need for effective remedies under European law, it is a discretion which your lordship should affirm the Court of Appeal's exercise of, albeit perhaps for different reasons or additional ones.
Thank you very much, Mr. Williams.
Lords, my lady, I'll try and be short. Can I deal first with the point made by my Lord Sumption this morning to me as to whether or not this is a question of the issue of discretion at all. I see a conceptual difference between a situation in which a person can be identified by one means or another. So, for example, the person who's stolen the Harry Potter book in the Bloomsbury case, or the person who's stolen the money and put it in a bank account in the CWOC case, from a situation such as this one, where there is no means of identifying the person at all and never will be. So in those circumstances, although it seems as if I'm taking an olive branch thrown in my direction because it does me good, I can see a conceptual difference as suggested by Lord Sumption. But whether I'm right about that, or perhaps I ought to say whether Lord Sumption's right about that in the way in which he put it to me, I suggest may not matter in terms of the way in which one approaches this case. Whether one does it on the basis that on the facts of this case, you simply cannot sue an unidentified person, or if one approaches it on the basis of considering whether there is a discretion to do so or not, I say comes to the same result. And the result is this: you cannot sue a person whom you cannot serve. And the reason for that is twofold. If you can't serve them, they never have an opportunity of defending the claim. And if you can't serve them, you can't get a judgment. So whether we look at it in terms of you can't do it at all, or there's a discretion whether you should exercise that one way or the other, the answer is when you can't serve, then you don't do it. And that, in our respectful submission, is a complete answer to this case, because this man or woman can never be served. Can I then turn to what I'll call the European dimension? And with respect to Mr. Williams, I hadn't anticipated, in the light of the way this was put in the Court of Appeal, or indeed in his case, that we would spend all afternoon on Europe. But my primary submission is that this case is not about European law at all. The issue which you are being asked to decide is a pure issue of national law. That is to say, can you organise, can the claimant put together a situation in which he can get a judgment against the tortfeasor? That depends on English procedural law and English procedural law only. The European legal context only comes into play in circumstances where he's able to say to you, it is acte clair that he's entitled to a direct right of action under Article 18, which you have to try and find some way of giving to him. Now, my lords, my lady, we say that far from being acte clair that Article 18 works like that, Article 18 doesn't work like that at all. If I can take you to it in Authorities Volume 1 at MS 1035, tab 11, the entire thrust of Mr. Williams' case is that as a matter of European law, we only have three types of vehicles: insured, uninsured, or untraced. Article 18 refers to a right of action against the insurance undertaking covering the person responsible. Now, if Mr. Williams is right, why doesn't it simply say covering the vehicle? Then it would be clear that a direct right of action was required in all circumstances where there was an insurance policy covering the vehicle. But it doesn't say that, and it doesn't say it in my submission because that's not what it means. What it means is that a direct right of action is only applicable in circumstances where there is a policy covering the person responsible. Now, that is a second reason why we say that's an end of the matter. If there is no direct right of action under Article 18, we never need to bother about the European perspective. Can I just take issue with a few points that Mr. Williams made on the recitals? I wouldn't like... They're false points, and I think it's right that the court should know. Recital 8, he said, was referring to the guarantee fund, in this case MIB. Well, with respect, it doesn't. I'm told, and I believe, that it refers to the green card scheme, which is referred to in Article 7, Recital 7, which is the previous recital. Similarly, Article 47, which is the information centres, that relates to the cross-border obligations of insurers and the guarantee fund, not to internal arrangements. And finally, on the directive in this regard, Mr. Williams was at great pains to explain that MIB could levy an excess. Could I ask you to look at 1033, Article 10, the fifth paragraph in the right-hand column in paragraph 3, the sentence beginning, however, where the body has paid compensation for significant personal injuries to any victim of the same accident, in which damage to property was caused by an unidentified vehicle, member states may not exclude the payment of compensation, nevertheless they may provide for an excess. Well, in the circumstances of this case, the vehicle is not unidentified, and therefore MIB could not charge an excess. Finally, my lords, my lady, can I remind you of something I said in opening and something that Lord Sumption has said? The directive is obviously, in the light of the discussion we've had this afternoon, intended to deal with a model which doesn't fit with the UK system. In the UK, we don't insure vehicles. And with great respect to Mr. Williams, the way in which he analyses directive responsibilities has to take that into account. And I can illustrate that if I may, and I'll take a moment doing it. I ask you to look at a case called Bristol Alliance, which you will find in Authorities Volume 1, at tab 16.
I think we have it at tab 18.
I beg your pardon, thank you very much. Tab 18. The facts of these...
could you give me the memory stick?
I'm sorry, yes, memory stick number 1144.
Okay.
The defendant insured by EUI, I'm sorry, the first defendant insured by EUI tried to commit suicide by driving his car deliberately at a building owned by the claimant, Bristol Alliance. Their insurers paid out and then sought to reclaim the money from the driver's insurers. They relied on an exclusion in the policy that said that their liability was limited in the sense of a limitation of use to exclude drivers' deliberate acts. The reason why I ask you to look at this case is because of what Lord Justice Ward said on the interaction of the directives, English law and the MIB obligations at paragraph 65 on page MS 1174. What has happened, and one picks this up at 1171, is that the court has been taken by Mr. Ross, who is acting for Bristol Alliance, to Ruiz Benaldez, Churchill, then Mar leasing principles, and although it's not mentioned, they were also taken to Candlin, all cases on which Mr. Williams relies. But at 60, perhaps I could ask you to read paragraph 65. I'm sorry, I don't require you to read the section from Singh and Solihull. It's the first part. Yes. What Lord Justice Ward does then is to demonstrate by going through the English authorities, Singh, and then AXA at paragraph 66, and finally the then House of Lords case of Clark and Cato, how the English courts have looked at the tension, and there's no doubt there is a tension, between the directives and English motor insurance law. And Lord Justice Ward ends up in paragraph 68 by saying, in effect, that the scheme of the Act, coupled with the MIB arrangements, satisfies the aim and spirit of the directives. Now, my lord, my lords, my lady, Bristol Alliance was before Fidelidade, but Bristol Alliance was cited with approval by the Court of Appeal in Sahin in 2016, a case I took you to this morning, and it was cited with approval and followed by Mr. Justice Ousley in Road Peace, and Road Peace contains a consideration of Fidelidade. My reason for making this point is that as part of English jurisprudence, the issues that Mr. Williams has raised have been considered, and the English courts at the lower level and in the Court of Appeal have concluded that if one takes everything together, there is no breach. My lords, that is all I propose to say, save for this, on the Article 18 point, finally. It's a repeat of something I said this morning. Mar leasing principles cannot be used to give the claimant the direct right of action, which for the purpose of this submission I assume she has. The reason is because the direct right of action is against the insurer, and what she's attempting to achieve is a judgment against the tortfeasor, and that's not the same thing. Lords, my lady, unless I can assist you further.
Thank you very much. Well, we're grateful to all parties. I appreciate you've been very pressed for time, and with the benefit of hindsight, it might have been better to have allowed longer. But we're grateful to you for completing your submissions in the time available. We're also grateful to those behind who've also played their part in preparing the cases. We'll consider this very interesting and important case and let you have our decision in the usual way.